versus Jefferson Parish School Board, Dr. James Gray. And we'll hear from Mr. St. John.
Good afternoon, Your Honors. May it please the Court, Scott St. John, Deputy Solicitor for the State of Louisiana. I'd like to reserve 5 minutes for rebuttal. A local school board adopted a policy that conditions a student's right to a free public education on, among other things, waiving their family's Fourth Amendment rights. That policy facially regulates the display of Botticelli's Birth of Venus in the student's home. It facially regulates the display of a locked gun case in the student's home. The state alleges that's unconstitutional and statutorily unlawful. It's not an accident or oversight.
Well, I guess I'm just wondering, why wouldn't you go to state court on all this? I mean, state court judges can address the federal Constitution. They're not barred from doing that. They do it all the time. So why wouldn't you, why are you trying to stay in federal court given that the district court didn't agree with that?
The facts were being developed in federal court. 2 students had filed lawsuits, so it made sense for the state to come in. The state was going to have to come into those lawsuits anyway to defend the constitutionality of its statute.
Right, but why shouldn't we remand the case to state court now?
The state has standing, and it, as the Third Circuit made clear in Porter, it would be a perversion, as Third Circuit's word, of federalism to deny a state, for whatever reason it chooses, the right to come into federal court.
You're going to have to talk about standing then. What state interest are you invoking distinct from the interest of the students and their parents, if any?
3 interests, Your Honor. First, the state has a sovereign interest in creating and enforcing a legal code. I'd point this court to its own case in Castillo, where Texas was found to have standing to appeal based on the idea that a federal court was either ordering or authorizing a local political official to violate state law. Violation of state law, unlawful conduct, is per se an offense against the sovereign.
How is Louisiana being prevented from enforcing its laws against the school board?
Well, the state is harmed per se by the violation of law. That generates sovereign standing. That's the sovereign interest. That's as Justice Stevens made clear in Vermont Agency for Natural Resource Development, that's why a federal court has Article III standing in a criminal case, even when it's just a malum prohibitum.
Still sort of bring to bear the same kind of full complement, the same arsenal of enforcement tools you have under state law to bring the board into compliance, right?
Absolutely, and the state absolutely can bring this case in state court. That's Audubon Park Commission, and we had a footnote citing 150 some odd years of state cases saying, yes, that we can do that. But both the Third and the Second Circuit have recognized that the state can come into federal court too. And because the case was already here, we already had 2 students, we were already obligated to intervene in those cases because they were challenging the constitutionality of the statute. Let's go ahead and resolve the state's claims too, rather than adding yet more litigation in state court.
So what were you had sovereignty, did you have more?
The flip side of the sovereignty is the state's quasi-sovereign interest in protecting its citizens from violations of their rights.
But how is that different than the interest of the students and their parents?
So the interest of the students and their parents do have that interest. Absolutely, no question. The state has an interest in obtaining broader relief. That was the point that Porter made, where the local political officials were trying to cabin the relief by saying, okay, you have 3 or 4 people alleging violations, they can get injunctions personal to them. What the state can do uniquely is avoid the Rizzo or LAV Lyons problem of limited injunctive relief. The state can come in and seek injunctive relief that would apply to the body of citizens as a whole.
Do you, and this shows my ignorance of the Louisiana system, so bear with me. Are there enforcement mechanisms, aside from suing in state court, available to you outside the court system? Are they considered a subsidiary government in some way?
No, the school boards are local political subdivisions. They are separately elected.
Not at all. it's, you know, we see today in the news and that sort of thing, some states, governors are taking actions against local school boards and things and having certain statewide pronouncements. Is there, you can't have this as a statewide pronouncement separate from, that you can't do this, can't ban people from displaying their.
No, Your Honor, not to my knowledge, and I would say that the state legislature tried to do that. They passed an act named after the child.
Right.
That's a very direct command to the political subdivision.
So it doesn't have any kind of, I guess, except through maybe the funding mechanism?
And we're limited on that as well because there's a state constitutional aspect to the funding of local education. So we're constrained, and in fact, it's the state that goes to the fiscal injury. The state is funding the political subdivision harming these kids, and the state is paying for this litigation, defending the school board harming its kids. The state is paying for the $100,000 settlement the school board paid out.
You have to do that.
We have to do that.
State law.
There's a minimum funding program that the state is obligated to fund public education.
Did you have something else you wanted to argue?
You're right. Like I said, this would create a circuit split if the court were to disagree with the Third Circuit in Porter, the Second Circuit in 11 Cornwell, and it would certainly be in severe tension with this court's opinion in Castillo.
Do you agree that if we disagreed with your standing argument, that we should remand rather than dismiss, though pursuant, similar to the 11th Circuit case?
Absolutely, Your Honor. 1447 requires remand of the case. It's a shall. It is non-discretionary. 1447E makes clear that remand includes any interveners or anything like that. It contemplates remand of intervener claims. So yes, if you disagree with us on standing, 1447C mandates remand.
But if we disagree with you on standing, we're creating a circuit split with the second and the third, is your argument.
Yes, ma'am.
Anything else you want to argue today, sir?
No, Your Honor. As I said, the state has three distinct interests: sovereign interest, quasi-sovereign interest, and fiscal. The district court all but ignored the sovereign interest as well as the fiscal interest. That was error, and we would ask this court to reverse, hold that the state of Louisiana has standing, and remand for further proceedings. Reserve the balance of my time.
Thank you. Ms. Masinter?
Yes, Your Honor, Eve Masinter on behalf of the Jefferson Parish School Board and Dr. Gray. As the United States Supreme Court has long recognized, Article 3 does not authorize a federal court to declare for the government of future cases principles or rules of law which cannot affect the result as to the thing in issue in the case before it. That's the Republic of Venezuela versus Philip Morris. It's a D.C. Circuit case, 287 F. 3rd 192, 2002, citing California versus San Pablo and T&R Company, 13 Supreme Court 876, U.S. 1893. The point is, Your Honor, is the district court was correct in finding no standing, no Article 3 standing. The judge dismissed the case. I'll get to in a minute the remand argument, if that's okay. What the state is asking for is an advisory opinion.
Why is it an advisory opinion if they have an interest in their sovereignty and in their fiscal?
There's no interest pled. This is, as you know, a motion for judgment on the pleadings. There was no interest pled as far as a financial interest. Similar to this court's finding in State versus Biden, there was no articulated fiscal interest other than a general financial interest. No facts pled, we lost money. This action caused this loss of money to the state. It's all hypothetical and speculative. That's what I say as to the financial. There's no allegation. It's not.
What about the sovereignty?
The sovereignty, well, the state has argued all along, and as Your Honors pointed out, the state could have filed suit in state court, but they did not. They
Right,
chose,
so why can't they be here if they want to be here? Why shouldn't we follow the Third Circuit's approach in Commonwealth of Pennsylvania v. Porter, allowing Pennsylvania to sue as parens patriae to enjoin the civil rights violations by local state actors going
well,
forward?
that case was before the Supreme Court's case in SNAP. And in SNAP, the United States Supreme Court carefully defined the parameters of the parens patriae standing.
Right, so you need to help us because
Because-
that Puerto Rico was held to have a quasi-sovereign interest.
Correct.
Systematic unlawful discrimination against its residents. So
That was
why doesn't Louisiana have a quasi-sovereign interest in preventing systematic unlawful discrimination against its residents similarly to SNAP?
It's not discrimination.
It's Second Amendment discrimination, isn't that, I mean, it's a discrimination.
That's not what they articulated as.
What is it that,
The state is claiming it's a violation of due process rights, that these students who are gone, due process rights were violated. They have not pled a Second Amendment claim.
but it's about them they were not given any process and they were thrown out because they had BB guns or something, isn't that right?
They had shown BB guns on the camera during virtual classroom.
But they were just in
And
the
they-
background. They weren't wielding them or pointing them to the students or anything, right?
No, they were moving, one of them was allegedly moving it in the face of the camera, and the other one did show it to the class and was holding it. But the point is, Your Honor, SNAP was eradicating discrimination based on ethnicity. It was because the Puerto Rican workers were not allowed to take advantage of the federal scheme for workforce established by 2 federal acts. And if you read SNAP, the SNAP court goes through historically where states have been allowed to express or assert parens patriae jurisdiction.
Why aren't the due process rights at interest here? I mean,
There's no
that-
injury, there's no concrete particularized injury as to any students other than the 2 students who were dismissed with prejudice because they settled. And further, the state, if you read SNAP, the court says in SNAP, I'm not being facetious, that one indication or a good indication of whether or not a state has a sovereign interest is whether they could not protect their citizens by legislation. That's what the state of Louisiana did. At the urging of the Attorney General, they amended the statute not once but twice. The Second Amendment was in 2021 while this case was pending. First, they provided the students in 2020 a right of review to the board if you were, and this is about students, just remember the narrow issue is about students recommended for expulsion who were then suspended, whether they had a right to a school board hearing, the right to judicial review, and now they were provided that, and they were provided that retroactively. These students were given that relief. It was given prospectively, plus the legislature provided for damages, attorney's fees, and any other equitable relief the court found sufficient. Then in 2021, the statute was amended to say in virtual learning, there can be no mandatory expulsion with a suspension. In other words, the provisions of the law that had required, and that was the disagreement between the state and the school board, was this supposed to be a mandatory expulsion under the statute? And if so, do you get the right to the review? That's all been amended. That's all been changed by the state legislature. So if you follow what the SNAP court is telling us, which is look to that, and if the state, has the power to fix it by legislation, that's the negative pregnant of SNAP. If they can fix it by legislation, they don't have that sovereign interest because they can fix it from the legislative branch. And they don't need to have the parens patriae quasi-sovereign interest to fix something.
So going forward, what is the situation?
Going forward, since the amendments,
Yes, for the students.
They now have,
For the 52,000 or so students in the school district, what?
they have a virtual policy passed pursuant to the statute. The Attorney General will say he disagrees, or the state disagrees, with the way that policy is written. The complaint intervention addresses only the interim virtual policy, which is gone. Just like the two plaintiffs are gone, the students are gone, that's gone. In March of 2021, the final, or let's just say the virtual discipline policy was passed to comport with the law's requirement that the school board have such a
Is
policy.
there another lawsuit going with that one?
No, because there's no allegation here, and there's no allegation by the state that any student has been disciplined under that
Well, probably people aren't on Zoom anymore for classes.
Well, that also,
But
Your Honor.
the difficulty in Louisiana, and I'm sad to say this, is of course there are hurricanes that sometimes shut down cities for quite some time, which may lead back to Zoom. So it's not like Zoom was a one-time, one thing that we'll never
Correct.
have again. So I'm not sure this is truly moot because, sadly, and again, I'm sorry about that, Hurricane Katrina, Hurricane Ida, things like that come and do create situations that last longer than the hurricane.
But is it right? Because no student, in the case presented to the district court and this court, in which the state intervened and chose to intervene versus filing suit in state court, that hasn't happened yet. That circumstance hasn't happened.
Yeah, but they're wanting to prevent it from happening. Why isn't that something they can do? That's not something the student could do.
That's
What
not,
about them?
no, it's not in their pleadings, and there's no injury. That hasn't happened. It's Rizzo. It's Rizzo all over again. It's the U.S. Supreme Court case in Rizzo. The Supreme Court there said you can't prevent what you think this police department and in police officers, what you think and how you think they're going to interpret and apply policies in the future. That was Rizzo, and that is parallel to this. The federal court, under Article 3, does not have the power to do that.
Does the school board concede that the state is not merely piggybacking on the plaintiff's claims, but they're asserting their own discrete additional claims for relief?
They attempted to, but there are no facts on which it is based. It's all hypothetical and speculative. It's what if one day someone does this to a policy that's not in my complaint and intervention, under a policy. So what if a teacher sees someone, that teacher makes a judgment call, that principal makes a judgment call, then that superintendent makes the judgment call, and then that school board makes the judgment call. You're having to, it's dependent, as the Supreme Court cases guide us not to do, it's dependent on the actions of third parties that are not in the case. It didn't happen. So it's all the chain of contingencies in Clapper and in Whitmore. That is the problem with the state's case. With remand, that's not allowed in this type of case as it's presented under the federal rules of civil procedure. The plaintiff sued in state court. The Attorney General or the state chose to intervene in two existing actions that were later consolidated. The Attorney General was never part of the state court action. The Attorney General can't go back to a suit it was never a part of. And I submit that under the federal rules and under the removal, so you remand something that's removed. The Attorney General was never removed. And under 1447C, and the cases we cited, it was, I believe, Samuels and Griffin. Once that case goes away, it's settled in both those cases, the Fifth Circuit has held you can't send just that intervention back. 1447C says the whole case, the entire case, gets remanded. And, I'm sorry, the case cited by the the state, the Gaines case, was a case where it was not, the federal court kept, and didn't dismiss it, but kept the case because the rest, the settlement proceeds, were in the registry of the federal court. So when the intervener made a claim for their attorney's fees in that case, they said federal jurisdiction remained because the rest was in the court. But remand is a thing that the state created. It's not something that can be done, with all due respect, under the federal rules in the posture that this case is in.
That's the best case for that, because we have so many mandatory remand cases in our precedent.
None of the cases cited by the state, but this case didn't come from state court. The case as it is now is
Come from state court.
the
It's just
complaint.
they weren't there
I'm
then.
sorry.
This case came from state court. They then intervened in it.
Correct.
So it did come from state court. You're just saying their part of it didn't. But the case did. This wouldn't be in federal court if it hadn't been in state court.
But the underlying case that was removed based on federal question jurisdiction because of the Section 1983 claims brought by those plaintiffs is gone.
Okay,
So-
but stuff evolves in federal court all the time. And that doesn't suddenly make it not the case from the state court. I mean, people change their complaint and so on and so forth. That doesn't suddenly make it, if you didn't make this complaint, you only allege these 3 causes of action and not this 4th one. Well, that's not remandable because it wasn't in state court. That's not how it works.
I understand that, but this is a different claim. I mean, this is a standalone complaint and intervention. The state is saying, I'm now the plaintiff. I am the master of my complaint. Yes, the master of your complaint, you filed in state court. Federal court. You chose to file in
But the
federal
state
court.
was allowed to intervene. It's not like they showed up with some new claim. Oh, now we're coming in on a car wreck.
But
They came in on a relevant claim and was allowed to intervene.
And they not only intervened, Your Honor, to defend the constitutionality of the statute, which claim no longer existed once the underlying claim went away, and they were permissive. Joinder was for them to intervene to defend Section 17416 as it existed prior to amendment under this court's jurisprudence as to the interpretation of that statute. That's gone. Let's say, okay, that's gone because the statute's been amended, so there's no dispute over the interpretation of the statute prior amendment. That's not going to affect any students in the future. But they asked for relief beyond that asked by the plaintiffs. They asked for the court to declare that, if you look at their claim for relief, to declare that 17416 is, wait, I'll tell you what they asked for. Let me just get to that. Declare that 17416 does not extend to non-disruptive conduct in the private home. They're asking the district court and this court to be the legislature, to say what does the law mean. And I don't know, Your Honor, I believe they're asking that the district court declare what the law pre-amendment meant, because that was the issue in the case. But they could say today they're asking for the law post-amendment. They want this court to interpret what does it mean, and does the statute that the legislature passed and twice amended extend to non-disruptive conduct in the private home? The state legislative body could have put that in the act. There's no case before the court. There's no injury before the court. There's no question in this case as to whether this statute extends to non-disruptive conduct in the private home. That's relief number one. Relief number two, declare that the school board has acted ultra-virus, in violation of 416 and 416.8. Those were the allegations based on the acts regarding the 2 students. 416.8 was the allegation that the school board didn't have a committee that didn't follow the statutory composition for the committee that was to pass its policies and amend its policies. The state did file a lawsuit in state court regarding the final discipline policy and argued that the school board failed to follow the open meetings law. That's in the 24th JDC, it's in our briefing, but it's number 814-558, and there was a consent judgment where the state, where it says, both parties acknowledge that the JPSB, Jefferson Parish School Board, reconvened a meeting of the disciplinary committee on March 1, 2021, in accordance with Louisiana's open meeting law. The purpose was for the committee to review and recommend any revisions to the virtual discipline policy, not the interim at issue in the intervention, and the code of conduct. And the committee's recommended revisions were adopted in March 3rd, 2021 meeting. Okay, I'm sorry, Your Honor.
No, I'm just confused if, you know, we're dealing with whether they're standing, and we've been talking quite a bit about that, but if there is standing, why wouldn't Louisiana have the right to at least get the first declaratory judgment, maybe not the ultra vires of unless it was either moot or unripe? That why wouldn't they have the right? And I think we already said it. You said it wasn't moot, or
No,
maybe you think it is moot.
Well,
you know, we would have to determine whether that relief was moot or unripe. And I think you think it's unripe as to the new.
as to the new law,
one, and you think it may be
it is moot
as to that's a step. You know, we have to first deal with. Well, I mean, you don't have to deal with if you think it's moot. That's a totally separate argument. But right now, we're dealing with whether or not they have standing to bring the claim.
Okay, I don't think they have standing to bring the claim because there's no concrete injury asserted as to any student other than the two students. So the state has to, under Supreme Court precedent and this court's precedent, cite to a concrete injury. There is no concrete injury in the pleadings as to any other student. There's no concrete injury alleged as to the state. That's your traditional Article III standing, right? A particularized concrete injury that is actual and imminent. Not there. We haven't even gotten to causation and redressability, some of which I was just addressing and we do in our brief of redressability. Then,
but you could do that first declaratory judgment, though, if it were appropriate and not moot or not ripe.
To declare that a state statute?
You're allowed to interpret whether the constitutional interpretation of the state statute and give the parameters of it.
With no underlying facts that lead to that.
Well, I think the underlying facts are the facts of this case. So I'm not saying it's not moot or it's not ripe. I'm just saying, hypothetically, I'm not sure that, I mean, that's not such a persuasive argument, is it? The idea that, oh, well, this is strange that they're asking for declaratory relief. That's very common.
So I could file a suit in federal court, say, without putting forth any facts, that I'm injured or I will be injured in the future.
Well, that's what they've been telling us about today. They may not be good enough facts, but they are telling us how the state is injured, both as parents patria they have the same claims as the students and the parents, and then they also have their own sovereign and financial claims. And they may or may not be good enough, and we have to go back and figure that out. But so it's not that they've not said no facts. It's that they've said these facts, and we have to decide if they're good enough.
They've set forth conclusory allegations. They have said we have federal grants, we have state grants, the school board gets federal money, and maybe one day one of our funding sources will be affected by the acts of Jefferson Parish School Board. Not This act occurred, and it caused me to lose my financial funding. This has been, of course, since 2020. These are just, we might. It's the same thing in Louisiana v. Biden with, you know, the interpretation of the, I forgot what those were. They were, hold on. It was the same type of non-financial injury as in that case. And I think there was another point you made that I wanted to speak to, but now. Oh, SNAP. Sufficiently substantial segment of the population. So what we argued in the district court found is that there is no effect, and the state hasn't articulated any effect on a sufficiently substantial segment of its population with respect to the allegations of these generalized constitutional violations and generalized violations of law.
Okay, I think you need to wrap it up now. Because
Okay.
your time has expired.
I think that's all I have then.
Okay, thank you.
Your Honors, I'll tick off a few things. Porter continues to be good law. SNAP was after Porter. 11 Cornwell was after SNAP. So Third Circuit before, it continues to be applied. SNAP obviously came in. Second Circuit applied, reached the same result. Fiscal harms, they were pled. That's at ROA 1251 and 1257 to 58.
Aren't they pretty speculative and not likely to occur now that the case has been settled as to certain plaintiffs?
No, Your Honor. I mean, you have a related to the injury question, you have a policy that is still in effect. This is not moot. The exact same language has been readopted. You know, this is this year's policy, exactly the same language.
Are you asking us to do are you asking the district court for a declaratory judgment against the current policy or the previous policy?
It's one and the same. It's the same language, put a different heading on it. So I don't think you can moot a case by having the local board say, okay, we're readopting the same language. That's not the policy that's at issue in that case. No, it's exactly the same policy. So that the harm is still there. On the harm, the state is harmed in its sovereign capacity. Yes, we passed a statute specifically to address this problem. That's the sovereign harm. The quasi-sovereign harm, we can stand in these kids' shoes. And just because the kids have settled out doesn't mean that the state's interest in protecting its citizens has gone away. That's the whole boatload of EEOC cases from both the U.S. Supreme Court and this court.
You know, we have had cases where the government has said, well, you know, we're not going to do this anymore, and we've changed our policy, and therefore we deal with whether it's moot. Is this a situation where the government has said they're not going to take kids out and suspend them?
No, Your Honor. Quite the opposite. The school board has consistently readopted, voted again, adopting the same language. And Judge Haynes, your point about the hurricane, the record on summary judgment, so outside the pleadings for the 12C motion, is that yes, last year when there was a hurricane, the school board forcibly put kids in remote learning. So yes, this is not a hypothetical. The policy says we reserve the right to do this again. It's still there. They've made clear that they'll apply it again.
So they're going to, currently the policy is, and the whole entire time has been that without due process, they can suspend students for a display of a weapon.
Yes, Your Honor. Or display of Botticelli's Birth of Venus. It facially forbids display of depictions of nudity. That's half the art in the Louvre. If that were in the background, that could result in the child being disciplined at the school board's discretion. What the state has commanded is that a policy for virtual learning be narrowly tailored to further a compelling government interest. I know the school board doesn't like that, but that's the policy, that's the state law, and the policy is alleged to violate that. on whether the state can pursue these claims, quasi-sovereign interests. The state, in its quasi-sovereign capacity, can't assert statutes. The cause of action is in equity. I point the court to Hawaii v. Standard Oil and Georgia v. Pennsylvania Railroad. Both are assertions of antitrust statutes. As long as it's not for damages, the state, in its quasi-sovereign capacity, can represent its citizens in seeking an injunction for a violation of law. On the remand issue, again, 1447E contemplates remanding joined parties. 1447 does not speak in terms of complaints or claims. Judge Haynes, you were completely correct. It talks about the case. You remand the case. The state came into the case. Certain parties settled out. The case remains. That's the Supreme Court's case in Local 93.
So it's not waivable.
No, Your Honor.
Required.
It is required. It is a direction to the court. It is mandatory. It is a shall from Congress to the court. And if there's nothing further, I'll sit down. Thank you, Your Honors.
Thank you. We appreciate the arguments from both counsel today, and this case is submitted. The court will stand